Welcome back, everyone. Today we're going to talk about federal preemption of state law. So this will be our last video in this series about federalism. So what is it? Federal preemption comes from the Supremacy Clause. The Supremacy Clause reads, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." So what this means is that when there is a law passed by Congress under the powers contained in the Constitution, that law is supreme, and any state law that conflicts with it is invalid. So you might be thinking, well, how does this fit with what the 10th Amendment says? The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. So, of course, these two things kind of work together to create some natural boundaries to this idea of federal preemption, because in order to preempt state law, the law passed by Congress has to be within its constitutional powers. So how does this work? We have a lot of questions, and we're going to try to get to most of those in this video. And first, we can ask, does Congress have to intentionally preempt state law? Or is this something that they can do just through passing the law? Is it possible for Congress to preempt state law by not doing anything or by not acting? Is preemption just about the actual text of the law, or can the way that enforcement of the law takes place, can that also preempt state regulation? So we'll be asking these questions, and what we'll see emerging is this continued tension between the Supremacy Clause and the 10th Amendment. So the role of the Supremacy Clause, of course, is that preemption flows from it. And the preemption of state law requires an appropriately constructed federal law. And we know that preemption certainly occurs in a couple of circumstances. One where there is a clear intent to preempt expressed by Congress, again, assuming that the law passed by Congress is within its powers, or when there is an outright or actual conflict such that complying with the federal law and the state law at the same time is impossible, or when the federal law implies a barrier to state regulation. And so sometimes this means that the federal law has sort of occupied the field, or has created one system for regulating in a certain area, and that this then bars state regulation. So let's look at how this happens in a couple of real-life cases. First, we'll look at Missouri versus Holland in 1920. The facts of this case have to do with birds. These are migratory birds, and the federal government first attempted to regulate migratory birds and protect them from being overhunted in a 1913 law, which the court found to be an unconstitutional use of federal power. Subsequent to this, though, the federal government engaged in a treaty with Great Britain dealing with birds flying across the border with Canada. And in order to kind of enact this treaty, Congress passed the Migratory Birds Act of 1918. And so the state of Missouri sued to try to keep the federal game warden from implementing this law, saying that it intruded upon state sovereignty. So the legal question at issue here is whether the treaty and the law enacting it are unconstitutional under the 10th Amendment. And the holding is a 7-2 decision, and Justice Holmes wrote for the court. And his argument was that the treaty power is explicitly given to the federal government in the Constitution. And this makes the enacting law necessary and proper to carry out this appropriate exercise of federal power. For this reason, if you look at that, Congress has the power to do this, and there's nothing in the Constitution, including the 10th Amendment, that forbids this kind of action. And he makes a point that this is an international issue, and that these birds are not sort of Missouri birds. These birds are only transitorily related to the state because they just kind of fly in for a little bit and then move along, right? And so if Missouri had its druthers, they would just hunt these birds until they were extinct, and that would impact not just Missouri, but the ecosystem across borders. In the next case we're going to talk about is obviously much more recent, Crosby versus National Foreign Trade. And the material facts are this. Massachusetts passed a law instructing its agencies not to do business or purchase goods or services from businesses that also do business in Burma. Okay, and this was in reaction to some anti-democratic actions and severe human rights abuses in Burma. In 1997, there was an executive order along with congressional sanctions against Burma. The idea here was that this regime was going to be used as an attempt to try to get some improvement in these human rights issues in Burma. And the legal question is whether the Massachusetts law is preempted by this regulatory regime. So the holding here is a unanimous decision that yes, this Massachusetts law is preempted by the federal government's action in Burma. And Justice Souter writes for the court, and he argues that Congress occupied the field in this area. And what this means is that Congress had created this all-encompassing system, and there was an internal logic to this system, right? That what they were attempting to do was have this highly coordinated effort to try to incentivize particular reactions from Burma in order to try to improve their human rights record. And the court found that the Massachusetts law undermined the purpose of the federal law, and it conflicted with the law, and of course also it undermined the president's authority to be making these diplomatic decisions. And so by Massachusetts sort of not playing ball with what the president was trying to work on through this system that was set up by Congress, it meant that it restricted his ability to pursue these international diplomatic avenues. And so it was preempted. And Scalia wrote a concurring judgment in this case. And this won't come as too much of a surprise. And what he says here is, I see no point in devoting a footnote to the interesting, albeit unsurprising, proposition that statements by the sponsors of the federal act show that they shared this intent. Of course, even if all of the court's indications of legislative history were not utterly irrelevant, I would still object to them, since none of this is a reliable indication of what the majority of both houses of Congress intended. And so this is another example of Justice Scalia relying on original meaning, not just for interpreting the Constitution, but also for statutory interpretation. Although he is considered an originalist, he does not believe in this idea of original intent or legislative intent. So the legislative history is irrelevant to him. Okay, so what do we get from Crosby? We get sort of a nice framework about what kinds of preemption exist. So the majority opinion talks about express preemption, and this is a fairly simple one to understand. A fundamental principle of the Constitution is that Congress has the power to preempt state law. So when Congress says this law preempts state law and makes it very clear, then this is express preemption because they are communicating very clearly what the intent is. There's also this idea of field preemption that we've talked about a little bit already. Here, this is when Congress intends federal law to occupy the field. All state law in that area is preempted. So this is what happens when we have this sort of all-encompassing, comprehensive legislative scheme that is intending to set up a complicated set of incentive structures and these sorts of things, that's having a bunch of different state laws that kind of interact with this system compromises the ability for that system to work properly. And then that's related to this idea of conflict preemption. And so state law is naturally preempted to the extent of any conflict with a federal statute. So in this situation, Congress doesn't have to say, we're intending to preempt either, a specific law, or we're intending to occupy the field in a particular area. This is a situation when it isn't possible to comply fully with state law and federal law at the same time. And again, if this law is something that Congress has the power to legislate, then it naturally is supreme and it preempts state law. So the next question, which is the last big question that we'll talk about today, is what about preemption on account of a regulatory scheme's intentions to have executive discretion when we're talking about implementing the law? So this is a little complicated. The easiest way to think about it is to just look at this case, Arizona versus United States. Now you'll notice there that Justice Kagan is blurred out, and this is because she worked on some of this federal regulation and on this particular conflict when she was the Solicitor General of the United States. So the facts of the case are this. Arizona passed Senate Bill 1070, and this was called the Support Our Law Enforcement and Safe Neighborhoods Act. And it had a number of different sections in it. Section 2B, it required police officers in the state to take reasonable steps to determine the immigration status of anybody they stopped legally. Section 3 required non-citizens to have with them these alien registration documents. And these would be federal documents that were obtained through the federal alien registration regulatory scheme. There's Section 5C, and this made it illegal for people without the proper work authorization or immigration status to seek or perform work either through formal employment or as contract work. And finally, Section 6 allowed for warrantless arrest when there was reasonable suspicion on the part of an officer that a suspect had committed a deportable offense. Okay, so obviously rolled up into that idea is this sense that in order for it to be a deportable offense, you would have to have some sense that the person would be deportable. So the federal government actually sues Arizona and argues that all of these sections of the law should be preempted by federal law. And the legal question here is, does federal immigration law preempt Arizona's cooperative law enforcement provisions? Now, we call these cooperative law enforcement provisions because there was a lot of the text of Senate Bill 1070 that was derived exactly from the federal statutes. Now, when you read the excerpts of these cases, you're going to see the justices talk about where the text of the law is very similar to federal law and where the state law actually does things that are different from what the federal law does. All right, so the majority opinion here, the holding is a 5-3 decision, and the answer to this question is yes for most of the provisions. These provisions are preempted by federal immigration law. And so Kennedy writes the opinion for the court here. And his argument is that properly enacted federal law preempts the states when they conflict. Now, the counter-argument here is that maybe they don't really conflict because a lot of this state statute is derived almost exactly word for word from the federal immigration statute. And the idea behind this law, indeed, was to sort of replicate this federal law into state law so that it would empower the state to have its officers enforcing this federal immigration law. So Kennedy argues that Section 3 actually conflicts with federal law, even if it is in a way complementary to that law. Section 5C conflicts mainly because Congress made a decision not to put criminal penalties on individuals for working. Section 6 violates the discretionary power of the president to decide who gets deported. So this is the one really big instance in this case where this law or this provision in the law is preempted because it takes away from the president the discretion to make these decisions about how to prioritize implementation of the law. And then Section 2B, this is the one where the officers were required to take reasonable steps to determine immigration status for people they stopped. And the court noted that, look, this hasn't gone into effect yet. We don't really know what it's going to look like when it goes into effect. Is this going to be something that is, already within the power of the officers and isn't really doing anything? Or is this going to be a real problem? And so they sort of shrug their shoulders and say, we'll wait for another day to reconsider this if it becomes a problem and it's brought to the court again. Now, of course, this is a quote from Kennedy's majority opinion. And here he's acknowledging the fact that this bill comes out of some frustration out of Arizona because these laws are largely on the books in the federal code, but they just aren't being implemented to the degree that Arizona would like to see them. And so Kennedy writes, Arizona may have understandable frustrations with the problems caused by illegal immigration, but the state may not pursue policies that undermine federal law. Now, there's some disagreement here, and so I'm going to go over really briefly the main arguments in the separate opinions. And we have 3 of them. The first one is from Scalia, and he is concurring in part and dissenting in part. And here he's concurring with the argument that the provision about determining immigration status is not preempted, at least not yet. But Scalia's main argument is that states have sovereignty over their territorial integrity. And, he uses some really aggressive language and basically describes Arizona as being in something like a war zone. And, notes that they have to have the ability to do something about this if the federal government won't. And so this is a quote from his opinion. He says, Arizona has moved to protect its sovereignty, not in contradiction of federal law, but in complete compliance with it. The laws under challenge here do not extend or revise federal immigration restrictions, but merely enforce those restrictions more effectively. If securing its territory in this fashion is not within the power of Arizona, we should cease referring to it as a sovereign state. Now, Thomas also concurs in part and dissents in part, and he agrees with the same section of the majority opinion that Scalia does. But he argues that, the problem isn't so much about Arizona's sovereignty. It's the fact that Arizona's law is almost identical to federal law. So he says it doesn't conflict with the letter of the federal law, And he talks about this idea that the majority opinion talks about, this purposes and objectives theory. And what this means is just that the Arizona law it is an obstacle to the purposes and objectives of the federal regulation. And he said this theory isn't appropriate because it makes us speculate what these purposes and objectives actually were. And of course, this leads you back down the rabbit hole of legislative history, which Scalia and Thomas are not big fans of. He also notes that the Supremacy Clause, in his mind, should apply to what Congress passes, not necessarily to these decisions, these discretionary decisions about enforcing the law. Now, Alito also concurs in part and dissents in part, but he concurs with different sections of the majority opinion. So he agrees with the majority on Section 3, saying that Congress had actually occupied the field here, that this requirement having to do with seeing these registration papers actually interferes with this overall sort of all-encompassing regulatory scheme that Congress had put in place. Now, as to the remaining two provisions, he said, look, with 5C, this is about regulating employment, and then he argues that this is a traditional area of state sovereignty. And as for Section 6, he argues that the conflict with federal law isn't really clear here. It's not certain that something about deciding to engage in warrantless arrests of people on probable cause of having committed a crime, this conflict isn't clear. And he makes the point that we should presume against preemption, at least in terms of congressional intent, unless that intent is explicitly noted by Congress. And so this kind of echoes a little bit what you hear with Thomas, that this isn't actually preempted, and that the majority is just sort of assuming that Congress had intended to preempt this by looking at this purposes and objectives rationale. So what does this mean for federal preemption? Well, in terms of the Supremacy Clause, it means that Congress can preempt states even if states pass essentially identical laws, and this is because they're moving the discretion involving the enforcement from the federal executive branch to the states, okay? And that this can interfere with the purposes of that federal law. Interestingly, this is related kind of a little bit loosely to the anti-commandeering doctrine that we talked about a couple of videos ago. Because remember, states can't be made to enforce federal law through creation of a regulatory framework. But here in Arizona versus United States, we see that they can't do it, maybe even if they want to. So they can't be forced to do it, but they also can't take the initiative and sort of pass mirror legislation in order to take over enforcement of something that is within the purview of congressional power. And so in Arizona, what this means is that, despite Arizona's attempts to try to enforce its version of federal immigration law, the Supreme Court stepped in and said, look, this is one comprehensive American government scheme, and it won't work to have each state sort of have its own set of laws dictating the enforcement of what are essentially federal immigration rules. So that's it for today. Next time we'll be back with a little bit on the Commerce Clause.